Companies are allowed to reduce the overall capital represented by their shares by undertaking a share buyback, in which the company itself buys shares from the shareholders, then extinguishes those shares. Sometimes a company might conduct a selective reduction of capital. This happens when one shareholder has a majority of shares in a company and they want to eliminate the minority shareholders to make the company a fully owned subsidiary. The rules are set out in Part 2 Capital J1 of the Corporations Act. To do this, the majority shareholder has to make an offer to the minority shareholders, and the minority shareholders have to meet. If 75% of the minority shareholders vote to accept the offer, then the buyback can proceed in relation to all the shares, even the shares of those who disagreed. However, as a final safeguard, any minority shareholder who objects can apply to the court to prevent the process proceeding. In this case, Winpar owned just 0.005% of the shares in Goldfields Kalgoorlie. 87.7% of the company was owned by a parent entity, the Goldfields Group. Insurer QBE was the largest minority shareholder with 11.4%, so Goldfields and QBE between them held over 99% of the shares. The shares were valued between 45 and 47 cents each, but Goldfields proposed to pay 55 cents for each share in the buyback. A meeting was held, QBE agreed to the price, and so the buyback was on. Winpar objected on a number of grounds, one of which was that it was unfair that QBE on their own could agree to the buyback, and this would be sufficient votes to compel everyone else to sell their shares. Justice Santow, however, found that in this case there was no unfairness. He said, "I am satisfied that the selective capital reduction was fair and reasonable, notwithstanding that QBE could determine the outcome of the vote. It could not be said that the interest of QBE was so divergent from that of the other members who voted that it would have been treated as a separate class. Closer scrutiny gives no cause for concern here. In any event, QBE indicated that it has obtained its own valuations." He found that QBE's agreement to the arrangement was in fact evidence that the shares were properly valued and that the minority shareholders were getting a fair go. The buyback was allowed to proceed.